For item 2, related to campus carry, the board has been provided copies of the rules, regulations, and provisions to be effective August 1. They are the same as provided to the board in May, with the exception of the UTRGB policy, which is before you in hard copy and contains 2 minor non-substantive revisions as highlighted on pages 1 and 3. We have received several requests to address the board on this item today. First, I will recognize Mr. Doug Dubois, Executive Director of the Texas State Rifle Association, to speak for 3 minutes. Mr. Dubois, would you come to the podium, please? Am I saying your name correctly?
Yeah, I was born in Beaumont instead of Lake Charles, so it's actually Du Bois.
Okay.
Instead of Dubois. But, like they say, I don't care
Nice
what you call me,
try, anyway.
just call me late for dinner. So, Chairman Foster, Chancellor McRaven, Regents, my name is Doug Du Bois, Jr., Executive Director of the Texas State Rifle Association, and I appreciate the opportunity to address you today on the issue of campus carry. The Texas State Rifle Association has been around since 1919, and we represent roughly 40,000 members across the state of Texas. I know I've got a very short amount of time, so there's really 2 primary issues that I want to talk to you about regarding the campus carry policy recommendations from the working group for UT Austin. The first concern proposes the empty chamber regulation for licensees who carry semi-automatic pistols on campus. This would not only render firearms useless as defensive tools, it would also force licensees to manipulate their guns upon entering campus property in order to comply with the regulation and subject them to violating the law by possibly failing to conceal their handguns on campus. We count among our members current and former law enforcement officials and firearms training instructors, and these experts with whom I have spoken all agree that this recommendation flies in the face of basic gun safety training, and it would actually diminish safety by increasing the possibility of an accidental discharge. The more often you handle a firearm, the more likely you're going to have an accident. In the 20-plus years our current carry law has been in effect, the legislature has never adopted a similar restriction on licensees anywhere else in the state of Texas. The second issue is the proposed policy allowing sole office occupants to restrict entry by licensees. We view this as a delegation of authority to university employees, which the legislature never intended, and we are concerned it could be enforced by those employees through verbal notice only. Senate Bill 11 requires an institution to give effective notice under Penal Code Section 30.06 with respect to any portion of a premises where licensees may not carry a firearm. Penal Code 30.06 requires this be given to the licensee by oral or written notification. A general announcement to a class of students each semester would not give effective notice, in our opinion. To every licensee on campus who may have reason to visit an office that the occupant wishes to keep off limits. It may give notice to those students, but other employees of the university that choose to carry on campus may not be notified. The university, the office occupant, and the licensee could all be non-compliant with the law, but only the licensee risks criminal charges for violating an ambiguous policy. It's our position the 2 recommended policies highlighted this morning do not follow the intent of the law as passed by the Texas legislature and would contribute to more confusion, less safety among licensees and the general campus population. Thank you again for the opportunity to address the Regents on this issue and be happy to answer any questions you may have.
Any questions of Mr. Du Bois? One quick question I have is you mentioned on your second point that if a person carrying a concealed weapon breaks the rules, that they could be subject to criminal violation. I'm not sure that's true.
If a office has been in the occupant's terminology given notice that it's off premises to conceal carry, and that licensee enters those premises, that's considered a criminal trespass. So it could be a violation of the law.
Any other?
Now, upon entry, the occupant asks, and we as concealed carry licensees are really not supposed to divulge that you're carrying concealed. And so, to be asked, are you carrying? If you are carrying, please leave the office. That could be written notice or appropriate notice and could be withheld.
Okay. Thank you very
All
much.
right, thank you.
All right.
Actually, it was high school in Houston.
The next speaker is First Sergeant C.J. Grisham, President of Open Carry, Texas, also recognized for 3 minutes. Mr. Grisham.
Chairman Foster, Admiral McRaven, the rest of the board, thank you for allowing me to speak today. As you mentioned, my name is First Sergeant Grisham. I recently retired last year from the United States Army. I worked in counterterrorism, counterintelligence, and various other jobs in South America and Asia. And gun rights is something that really means a lot to me. And there's, first of all, I would like to commend the working group as well as the implementation committee, because I think by and large, the committee has come up with a policy that really meets the spirit and intent of the law. I'm going to kind of reiterate some of the things that I think the Texas State Rifle Association is accurate on that we also disagree with. The loaded weapons is very important. I trained my soldiers on proper weapons management, on how to carry firearms, and you keep them loaded, because if you need that firearm in an emergency, the last thing that's probably going to go through your mind is whether or not that thing's loaded, because you may carry it loaded all the time. And if you go into a building because of the policy, you have to unload it. In your mind, you think that gun is still loaded in an emergency. So that, first of all, I think is unenforceable, but I also think it violates the spirit and intent of the law, and as well as Section 23 of our state constitution, only gives the legislature the power to regulate the wearing of arms. So it's kind of irresponsible to ask to do that. When you're also unloading and loading weapons, whether it's in a parking lot before you go to class, or, you know, what if you're going to a building or going to class and then you realize, well, my weapon's loaded. Well, where do you go to unload your weapon? Right there. Do you hide behind a tree or go into a bush or reach into your backpack and try and manipulate it that way? So that it just creates more problems, and that's when accidents happen. The second thing, I think that policy statement number 16 should also be stricken. I think that keeping guns out of dorms creates a general prohibition on those that live in the dorms, and I think that violates the law in itself. I think that your policy statement number 17 mitigates that risk if you just require gun safes in those dorms, just like in the regular policies. And then lastly, I think it's policy number 4 that talks about youth programs and being able to put up signage as there are youth programs in various areas. The legislature has only indicated that actual K through 12 school-sponsored events can be gun-free zones. That includes sporting events. That includes if there's an event in the parking lot. So when we say that youth programs that aren't sponsored by a K through 12 school suddenly create a roving gun-free zone, we also believe that violates the law. We are no more in danger whether there's an adult around or someone in a youth program. And so that's going to also create some confusion if we've got these kids that are going all over the place, but it also, we believe, violates the spirit and intent as well as the legislative passage in what is a youth program. It's not even identified in Texas code. So those are some of our points and our concerns. I think again, the board and the committees, they came up with an overall great policy, but I would ask that the Board of Regents strike those 3 areas as not meeting the spirit and intent.
Okay. Questions?
Thank you
very much.
Appreciate it.
Next, I'd like to recognize Ms. Elise Avina for 3 minutes.
Thank you. My name is Elise Avina, and I am a senior at UT and the president of the student organization Students Against Campus Carry. The organization speaks out against the implementation of SB 11, but we respect that this board has a duty to the state to uphold campus carry. We all desire here today to maintain a well-protected, peaceful learning environment that will continue to cultivate the great minds and great innovations UT is known for. The policies discussed today come to us through the expertise of administrators, students, professors, faculty, and our campus police department that assisted the UT working group. Our representatives have jumped through every hoop imaginable to ensure the safety of students and faculty has been validated while still upholding SB 11. With this in mind, I respectfully request that you adhere to the policies set forth by the working group and President Fenves. The policy regarding chambered rounds and concealed handguns has been the subject of much scrutiny. The issue was whether the action of removing rounds from the chamber before entering a campus building was more likely to lead to an accidental discharge of a weapon than if the weapon was already loaded. It is hard to determine this due to a lack of extensive data into such a specific circumstance. Yet every gun owner is all too familiar with the risk of accidentally discharging weapons. Even professionals with extensive training understand that any firearm, loaded or not, is a threat. Consider the UTPD officer whose gun fired through his leg on campus this May. The news station KXAN has recorded 20 such accidental discharges by officers since 2008. Many more incidences involving accidental discharge have already occurred to both students and faculty who live in states where campus carry has already been implemented. Though this might seem counterproductive to CHL holders' primary reason for carrying a handgun, self-defense, the Harvard Injury Control Research Center reported in 2007 to 2011 survey that most purported self-gun defense uses are gun uses in escalating arguments, and that firearms are used far more to frighten and intimidate than they are used in self-defense. We believe that the choice should be an unchambered round. Respect our campus decision, review the evidence in 1 year, and if it needs to be revisited at that time, it can be done. The amount of senseless death and injuries caused by gun violence these past 7 months have left us students dejected about the amount of impact we can truly have in the face of campus carry. The working group has done a tremendous job in doing research, following the law, and proposing policies they believe appropriate to serve our unique community. While I do not support the law in general, I believe that the current working group plan should be maintained as it will better ensure student safety. Thank you.
Thank you. Any questions of Ms. Avina? If not, thank you very much.
Thank you.
Next, I would like to recognize Mrs. Anna Lopez to speak for 3 minutes.
Chairman, Chancellors, or Regents. My name is Ana Lucia Lopez, and I'm starting my second year at UT as a pre-med student in the Plan 2 Honors Program. When I accepted my offer of admission last May, I knew not of the prospect of having guns on campus. Suffice to say, the subsequent passage of SB 11 has proven to be quite an encumbrance, an event that could forever dim the enchanting sparkle in the eyes of Texas, if you will. However, I would like to sincerely thank the Campus Carry Working Group, Chancellor McRaven, President Fenves, for their exhaustive work in implementing this unfortunate law in a way that seeks to protect students, faculty, and staff alike as much as possible while still abiding by the rules. Guns have no place on a college campus. I know that, you know that, the Surgeon General knows that, and goodness knows the whole world knows that. However, we have to wait for the Texas legislature to catch up. Today, the Board of Regents will meet on the issue of guns in professors' private offices. Now, I cannot personally speak for the professors at UT. However, I mentioned my major, pre-med and Plan 2, and you can safely assume that I know my way around office hours. This may not apply to the hard sciences, but the time I've spent one-on-one with my Plan 2 professors has been invaluable. There, I'm free to speak on widely contested political issues, personal problems, and grading. I feel safe to speak my mind, and so should my professor. This particular environment allows for the shifting of ideologies and the freedom of expression of idiosyncrasies that could otherwise be silenced by the pull of a trigger. Professors should be able to turn up their nose at the nose of a gun through proper signage per Penal Code 3006, supplemented with verbal notice without question. So, on behalf of the vast majority of professors against SB 11, including those who have resigned already, and the student body of UT, let us do what we can. What starts here changes the world, so let us start here until this law is repealed. Let us be the model for public universities and create as many bulletproof roadblocks as possible. I don't want to just throw up my hands yet. The world is watching. Thank you.
Thank you.
Any questions?
Questions of Ms. Lopez?
Thank you.
Thank you very much. Then what about? Okay. Are there further comments or questions from board members on this topic? Wallace.
So you're about to ask for if there's any motions, so this is our last chance to have any conversation, correct?
Well, we could discuss it now, or we can discuss it as each motion is.
Well, whichever. I just want to make sure I didn't miss
But
the
yes, well,
opportunity.
I will make sure
Okay.
we have time for discussion.
Thank you.
And yes, now I'm asking if there are any motions related to these policies. You want to go first? Or
Regent Hall.
Please, after you. Seniority.
Thank you. Thank you, Mr. Chairman. In the spirit of assuming the greatest possible safety and compliance, I offer the following motions. I move that the board, by a vote of at least two-thirds of the full board, revise the UT Austin policy by removing the requirement that a license holder who carries a semi-automatic handgun on campus must carry it without a chambered round of ammunition. I further move that the board delegate to the Chancellor authority to review and determine that the final published campus rules and policies conform to the direction of the board. That is my motion, Mr. Chairman.
all right, and before I call for discussion, do I have a second on that motion? Second. Thank you. Discussion? I will say that I know that it's, this is a topic of a lot of discussion and concern, and legitimately so. I personally am persuaded that all of the experts that I've heard from, and I think without exception, believe that there's more danger involved in moving bullets in and out of the chamber than just leaving the gun loaded. In addition, I do believe that an empty gun is not a weapon, but an invitation to get yourself hurt. So I, for one, am going to support your motion. But is there any discussion, Steve?
Just my perspective, and I think I'll be in the minority on this, but I too am not convinced about the open chamber policy. But I get back to respecting the work that the working group and the faculty and students and the staff have done on this. They spent months and months putting this together. So I am probably going to vote against the amendment, just to vote with the group that did the work to put it forward. So.
Okay, Sarah?
Thank you, Chairman Foster. I too, as you heard me say at the last Regents meeting, I too am moved by the process that was used. In my mind, as someone who grew up in a ranch, I also feel like all the experts that we've heard from are trained law professionals who are exposed to this every day. And I do see a difference between a concealed gun holder, licensed concealed gun holder, as opposed to a professor. And I just, with that doubt, it's hard for me to overturn a deliberate process based on the readings that I've had. So I also plan to vote against this motion.
Brenda?
I see in the motion that the issue of faculty offices is not addressed. I go back to the Austin policy, and I made this comment in May as well. It's written too vaguely, too broadly, if you will. The way I interpret the policy is there's no justification or documentation required at this time to make it an exclusionary zone. So for that reason, I agree with the motion, I am compelled to vote no because I deem it incomplete.
Well, with respect, if you want to make a motion regarding the offices, I think you should. I'm not sure that should affect your vote on this issue, but
Well,
vote your conscience. But
but this is, if this is the vote in its entirety, to me, it doesn't address the entire issue. So
I'm going to make the motion.
okay.
I'm compelled to vote no because I look at it as being partial.
Could I have some clarity on what this process is? As I would understand it, Vice Chairman Hildebrand has put forth one motion, but that the floor will remain open for additional motions to cover
Right.
every other topic, so that if we wish to vote for one thing and against another thing, we'll be free to do so.
Absolutely.
So,
Or if you prefer to offer a motion on another topic or on the same topic.
I have a motion, but I think I'd probably prefer to offer it is distinct and different than the topic Vice Chairman Hildebrand is talking about.
Okay.
So I'll offer that after we've dealt with
After,
this
right.
specific issue of chambered round, I think.
Okay, Ernie.
You know, Mr. Chairman, I think that one of our responsibilities as board members is to look out for the safety and welfare of not only the students but the faculty on each of these campuses. And I certainly respect the working groups' work and process as it relates to the chambered round. But I certainly agree with you that the evidence that we've heard tends to indicate that it's safer to have the weapon with the chambered round, where you don't have the going back and forth of taking out bullets. So I tend to agree with you, Mr. Chairman, and you have my support.
Regent Beck.
Yeah, I too want to compliment the working group for all the extensive and excellent work that they've done. And I tend to want to defer to all the work that they've done. However, we do have an independent office for our students, our faculty, and other concerned groups. So although the chambered round issue, if you will, I think it's a very close call, but I'm persuaded to vote in favor of the motion.
Any other questions, comments? Jeff?
Mr. Chairman, I would simply say on the chambered round, the reason I offered up the motion is once again just to reaffirm that the body of evidence that we've received shows that it is inherently safer for the students, the faculty, the administrators to not allow guns to be chambered, unchambered, kind of on campus. And so the less that one manipulates a gun, which is what our expert has told us, the better and the safer it is. That is the reason that I've proposed my motion. I would say as well, I have removed the faculty office provision that we spoke of previously, and I think we'll probably have more discussion around that.
Right, and I think that's a separate issue, and it's appropriate that we look at them separately.
Yeah, and I understand that now. We'll look at that separately. So I've been persuaded. Thank you.
All right, call for a vote. All in favor?
Aye.
Aye. A little delay there. And opposed?
Aye.
One, Steve, and Sarah. Okay. It passes 6-2. Or 7 if I vote.
But it does pass the two-thirds test.
All right. Thank you. So that motion passes. I will now ask if there are further motions. Wallace?
Yes. Prior to making the motion, I'd just like to make a comment about why I'm making this motion. Not only is our responsibility to the safety and welfare of all those students and faculty and staff and visitors to our campuses, but it's also to adhere to the law. And I don't believe that UT Austin's policy does that. And I think it needs to be amended. I think it's very clear from our conversations, both in public session and in executive session that the ambiguity in regard to the decision-making process of faculty members being given sovereignty to determine the gun-free status of their office and whether or not there's criminal liability or not criminal liability is indicative of the fact that that it's complex and it lacks standardization. It increases the balkanization of the rules, and it makes it, I believe, more difficult for the police to know when and where guns are allowed. So with that, I move that the board, by a vote of at least 2/3 of the full board, amend the institutional policies regarding concealed handguns on campus to ensure that there are no exclusion zones imposed on license holders within student housing, including dormitories and university-owned or operated apartments. This does not preclude regulations requiring storage or specifying the type of storage within a student residence when the handgun is not being carried by the license holder. I also move to eliminate the UT Austin provision allowing employees to prohibit concealed carry in their individual offices at their discretion. I further move that the board delegate to the chancellor authority to review and determine that the final published campus rules and policies conform to the direction of the board.
Thank you. Before we have discussion, let me call for a second.
Second.
Thank you, Brenda. Questions or discussion? I'll offer my opinion. I consistent with several remarks from board members on the last motion. I do want to compliment the working group and Dr. Fembus, and I believe it's incumbent on us to, number one, review these policies very carefully, but number two, unless there is a compelling reason, the legislature has directed us to allow the individual presidents to set their policies. On the bullet in the chamber, to me, that's a vital safety issue, and I felt compelled to change what Dr. Fembus recommended. On this one, this is more of an administrative, I think, and procedural, not necessarily a direct safety concern, at least the way I view it. So I'm not inclined to support the motion, but I'm open to discussion. Jeff.
Thank you, Mr. Chairman. I too will not agree to the motion, accept the motion. In many ways, I believe that President Fembus, the working group, the faculty, we need to in effect defer to them out of respect to them, give them some control of their environment. These are unique. These are unique environments that the faculty lives and works in, and I, for one, want to preserve the uniqueness of an academic setting. And if the faculty members don't want guns in their offices, I think they ought to be allowed to have that authority.
Steve?
I would agree on that specific issue. I mean, I don't allow guns in my office, and I think a faculty member, especially as we try to recruit the top faculty from around the country, that they ought to be able to have that option as well to decide whether their office is a gun-free zone or not. It just makes good sense to me. So I support that choice, which would mean I would be voting against the amendment.
Wallace?
So I asked the question before, if I were a professor at the university and I orally precluded others from bringing a handgun into my office, can I still have a handgun in my office? And the answer was, nobody knows the answer, and I don't believe anybody still knows the answer. So the idea that you can grant, or let me say it differently, the idea that you can take away one person's rights to carry a weapon to defend themselves in favor of someone else is not appropriate. And that's what the current law, or that's what the current rules as proposed by UT Austin do allow.
I have assumed that if an office is a gun-free zone, that would apply to everybody in there, including the guy whose office it is. I don't know if that's exactly. Dr. Daniel, you want to?
That would be my interpretation as well, but again, that's my opinion.
So we have a presumption and an opinion.
Well,
but what's the rule? And that's the problem when you start breaking up the rule to allow certain individuals the right to a different level of rights than somebody else. And so I think that just highlights one of the problems with this.
Dr. Femis? Are you in there?
Yes.
Huh? What would you mind stepping up to the table and getting on the hot spot? The way it's written, is our interpretation correct that it would apply to everybody in the office, including the office holder?
That's correct. The declaration is it's a gun-free zone.
Okay. And if the language needs to be tweaked to make sure that that's the case?
Well, that's the intention,
okay.
And if we need to tweak the language, we certainly can do that.
Okay.
But that was the intention of the policy.
Thank you. Anybody else? Ernie?
President Fenves, and it's my understanding that you've consulted with your experts, and these things meet, in your opinion, legal muster based on what your experts have told you.
So through the extensive process with the working groups, there was considerable consultation with counsel. The working group itself had 4 lawyers on it, including a former Chief Justice of the Texas Supreme Court that's very familiar with civil law in Texas. And we feel very confident that the policy is within the authority of the university, within SB 11 and other related statutes and court precedents.
Thank you.
Anybody else? Thank you. So we'll call for a vote. All in favor?
Aye.
Aye. I'm sorry. All in favor of Wallace's motion that we limit?
Aye.
Okay. 2. Okay. All opposed?
Aye.
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 But you're for it.
I think it's 7-2. Okay. That motion fails. Do we have further motions? Brenda?
No.
No?
I have a motion.
Alex?
I further move that to provide better clarity as to which areas exclude handguns, to protect the privacy of CCL holders, and to assure office occupants that any past verbal notice is actually effective, the university policy require a reasonably clear written signage associated with identification of gun-free zones.
Second.
Okay. And is that the whole motion?
Yes.
Okay. And you seconded? Sorry. I thought you sneezed, actually. So open that up for discussion. The law, as it's stated, if we didn't amend it, per Regent Cranberg, is that either verbal or written notice is appropriate. And I don't know if anybody's seen what these signs have to look like to give effective written notice, but they're about 3.5 feet long and 2.5 feet wide, and they basically take up if there's a window on the door, it's going to cover the whole window.
To be clear about my motion, it does not specify that a written notice be compliant with the state notice requirements, as this is would be a university policy. So if state law requires verbal notification, and if verbal notification is effective for state law purposes, that's all that's needed. I'm suggesting that for clarity within our own institution, that we can have a university policy that raises a higher bar but doesn't necessarily specify one which complies with the state law alone signage requirement. Of course, I think we've all seen these signs at lots of stores, and they're commonplace these days. But I'm not suggesting my motion would not require that a sign be that large, but it would require that written signage that I think I suggested is reasonably clear written sign be supplement a verbal notification. Of course, if somebody chose to put a large sign that was compliant with state law for written signage purposes, that would be adequate. But if someone is relying only upon the verbal notification, that would presumably be required virtually any time somebody comes into the office. It struck me that it becomes very difficult to enforce. It's not if a faculty member is concerned about firearms in their office, they should want to have a more obvious written notification. And I'm concerned that relying only upon verbal notification could lead to an incomplete and ineffective policy on our part, and could also potentially impair the privacy rights of a CCL holder to be asked whether or not, are you carrying a weapon or not, for example.
Repeat his motion. Got it, and I think the board might benefit from hearing it.
Okay. Why don't you repeat your motion?
I further move that to provide better clarity as to which areas exclude handguns, to protect the privacy of CCL holders, and to assure office occupants that any past verbal notice is actually effective, the university policy require a reasonably clear written sign be posted in front of such office.
Okay. And your second is
I'm
still
second.
Okay.
I just had a question. Is there any other, if he's going to the smaller sign, is there any reason not to provide written notice on a faculty member's office that has declared it a gun-free zone?
Well, I mean, I think that's
I'm
what
just
the
asking a
discussion's
question.
for.
Yeah, I'm asking a question.
An interesting question. Dr. Fembus, I hate to make you pop up again, but how do you think your faculty would respond to this requirement? I know you can't speak for all of them.
Well, thank you, Chairman. So this issue of notification in the single occupant offices had a lot of discussion, and any signage short of the official Texas Code 30.06 sign has no legal standing, and so we are normally not in the business of telling faculty what the signage they can put on their office or what they can't put on their office. There is academic freedom, free speech rights that are important at the university. And so since any signage that we would require has no legal standing, the working group's conclusion was that there should not be a requirement for signage and that the oral notification was sufficient under existing law.
Wallace?
So I guess my question is, though, is there any downside to it in terms of if it improves the safety and welfare of those on the campus and removes ambiguity and confusion, having that signage?
Well, again, I don't believe we have any regulations that tell faculty what to post on their office or not to post on their offices. But license holders, part of the training is to be familiar with the law. And I would be concerned that if there was a campus policy that wasn't consistent with statute, that could introduce just as much confusion about what the status of the office was. If there were signage, not official, not legal signage, but no verbal notice, and that would introduce confusion on its part.
But doesn't the signage reinforce the idea that every person that comes into the office received an oral communication that guns weren't allowed? I mean, this way there's no he said, she said, or differences in remembrance.
Well, again, the signage has no, there are lawyers on this board, and we've had lawyers I may call on. The signage has no basis for either the occupant or a license holder. It is only the verbal notice.
Well, I mean, to comply with this, I'm not an attorney, but to comply with the statute, the oral notice complies with the statute.
Right.
The signage that Regent Cranberg is suggesting is just further clarification and notice to reduce ambiguity and conflict. I mean, there's a lot of signs that we have presumably all over our campuses that aren't there for purposes of statute, but for communication. So is there a downside to having this signage to eliminate or reduce confusion?
So if a license holder goes into an office, does not receive an oral notification, but sees a sign that's not compliant with Texas Code 30-6, what do they do? What's the status of the office? Under the law, it is not a exclusion zone.
Okay, I would agree with you. So there is no issue with that.
There isn't.
So I'm talking about I'm looking for the situation where a faculty member said, it's just trying to eliminate confusion. I mean, I don't understand why it would be a bad thing.
Well,
I just got down. How many faculty members do you have at UT Austin?
we have about 2,500.
So if we're going to have this written sign for every one of those offices, we're talking about 2,500 signs, which is going to be I'm not talking about the expenditure, but we're going to have signage all over the campus. Is that correct?
If substantial numbers of faculty decide to or are required to put up signs, yes.
Okay, and from a common sense perspective, obviously, if you have something in writing, that's better than having it just orally. But my question is, if faculty offices are gun-free zones, doesn't that mean no one can have a gun in that zone?
That's correct.
One last question. Is it possible that people don't want signs on their offices that say no guns allowed because then it would be obvious that there's no guns allowed? I mean, nobody wants to be identified as the place where it's a gun-free zone. Isn't that true?
I don't know if I could speak for everyone.
I mean, just as a question of logic.
Can you repeat the question?
As a point of clarification, it was just pointed out to me that this applies to more than the 2,500 faculty. It also applies to staff. So, and I think on the flip side, I'm not sure all 2,500 faculty have an individual office, but so to whatever difference that makes, just to clarify that it applies to any office.
It applies to any office with a single occupant. So shared offices, this would not apply to because people come and go inside offices with multiple occupants.
So, is the idea that literally to make a verbal notification effective, say for a staff member, that they would have to consistently tell anybody that entered their office this is a gun-free zone? Or would it just be?
That's correct.
Seems like that's a lot more verbal difficulty than.
Well, it would be their responsibility to do that if they wanted to exclude handguns from their single occupant office.
Sarah?
So my question is really more about practicality, which is whether it's faculty or staff. I assume that the number of individual offices at UT Austin is greater than 2,500. And so my question would be, how do you enforce and ensure, and what happens if somebody doesn't post but does the verbal? I mean, what kind of governance issue does this create for you if we're going to mandate that much, and how do you enforce it?
You're talking about the policy as proposed or the signage?
If we were to say that we're going to amend it and we're going to want to supplement, I don't think it eliminates the he said, she said, because if the sign doesn't have any legal standing, it's still your word against mine. So I discount that. But I do worry about if we were to change it and it's a number north of 2,500, what position do we put you or your provost in terms of making sure that the signs are up, they're consistently up, and what is the recourse if it isn't up?
Yeah. Well, so that's a very good question. Of course, this is new to me, so we haven't thought this through. But if this were the campus policy and an occupant gave verbal notice, but there wasn't a sign up, that would violate the policy, and we would have a disciplinary process to follow. as true for any violation of campus policy.
It seems to me that your comment about the sign not being enforceable, I agree. It doesn't meet the ridiculous requirement that the big huge sign that you have to put on doors. But what we're talking about is setting policy, and we can define our policy, and so I think it would be enforceable from a policy standpoint, not from a legal enforcement standpoint.
And all I'm saying is it puts faculty through a disciplinary process, and how attractive are we as a university is if you choose to use what's legal, which is verbal, but you don't post for whatever reason, you put people through a disciplinary process, and is that really necessary when an academic campus is supposed to give faculty academic freedom?
Yeah, and it's a tough issue. I mean, how do you prove somebody gave verbal notice? You didn't write that law, and I didn't write it, but it's kind of hard to it's kind of hard to implement.
Well, this exists now. So if a private establishment that doesn't have a posting prohibiting concealed handguns, and the owner or operator of that private establishment can give verbal notice,
right,
and it's the responsibility of the license holder then to leave the premises. So this is existing, long-established procedures in Texas.
You can do that at your office.
But we're a public institution. These are owned by the people of Texas. It's not private.
Yep.
So, assuming that there is no sign requirement, isn't it true, and we all believe that oral notice is sufficient pursuant to the law, if a particular faculty member wants to post the sign voluntarily, would you allow that? And wouldn't that give kind of the absolute amount of freedom to control one's environment?
Thank you, Regent Hildebrand. Yes, faculty members are free to put signs up in their offices. We do not regulate
Great. Thank
what
you.
faculty put in their office.
All right. Other questions or comments? Is everybody clear on what the motion is?
Mm-hmm.
Call for a vote. All in favor
Aye.
of the motion by Regent Cranberg?
Aye.
3. All opposed? 1, 2, 3, 4, 5, 6. So the motion fails barely, and that's that. Do we have further motions? Thank you. If not, we will move on. Next, Chancellor McCray.